The Americans with Disabilities Act, since its inception in 1990, has been a cornerstone in safeguarding the rights of individuals with disabilities in public domains, including educational settings. The history of ADA is marked by a significant shift in societal attitudes and policies towards individuals with disabilities. Rehabilitation Act of 1973 was the first U.S. federal law to protect the civil rights of people with disabilities. Section 504 of the Act prohibited discrimination against people with disabilities in programs that received federal financial assistance. However, its implementation was delayed, and its regulations defining its application were not finalized. Frustrated by those delays, disability rights activists organized protests across the country in April 1977. The most notable one was the sitting at the San Francisco office of the U.S. Department of Health, Education, and Welfare. The protest was led by the American Coalition of Citizens with Disabilities. The sitting lasted for about 25 days, making it the longest non-violent occupation of a federal building in the United States history. The protesters received significant support from the local community, politicians, and other civil rights groups. The sitting was successful in applying pressure to the government. On April 28, 1977, the Secretary of the San Francisco office of the U.S. Department of Health, Education, and Welfare signed the regulations implementing Section 504. This victory was a significant step forward in disability rights and set the stage for future legislation, including the Americans with Disabilities Act of 1990. The ADA was signed into law by President George H.W. Bush on July 26, 1990. It was a landmark piece of civil rights legislation that prohibited discrimination against individuals with disabilities in all areas of public life, including jobs, schools, transportation, and all public and private places that are open to the general public. Over the years, the ADA has continued to evolve through court decisions, amendments, and regulations. It has significantly influenced the design of public spaces, transportation, digital technology, and workplace policies, ensuring greater accessibility and inclusion for people with disabilities. According to Pew Research Center, as of 2021, there were approximately 42.5 million Americans with disabilities, constituting about 13% of the civilian non-institutionalized population. The disabilities include difficulties with hearing, vision, cognition, walking, self-care, or independent living. Notably, American Indian and Alaska Natives, along with Black or African Americans, reported higher prevalence rates of disability. The ADA Amendments Act of 2008 further reinforced the protections by broadening the definition of disability, thereby increasing the number of individuals eligible for protection under the ADA and related laws. This expansion includes not only physical impairments, but also major life activities such as sleeping, walking, learning, thinking, and working, and bodily functions such as immune systems and digestive, neurological, brain, and reproductive functions. Despite the broad definitions of what constitutes a physical or mental impairment when it comes to disabilities, there are specific situations where a person may not be classified as having a disability under those regulations. For example, people who have a contagious disease or whose condition poses a direct threat to the health or safety of themselves or others may not be qualified as disabled. This is because the primary concern in those cases is the safety and health of everyone involved. For example, a teacher has an active case of tuberculosis a contagious bacterial infection that primarily affects the lungs. Well, TB is a serious health condition. If the teacher is actively contagious, they may not be classified as disabled under federal regulations for disability protection. This is because their presence in the school could pose a direct threat to the health and safety of students and other staff. The primary concern here is to ensure the well-being of everyone in the work environment. Once the teacher receives proper treatment and is no longer contagious, they could be considered for disability protections if there are long-term effects from TB that impact their ability to work. When determining if someone's health condition disqualifies them as disabled, the decision must be based on current factual medical information. It's important not to base those decisions on stereotypes, generalizations, or unfounded fears about a person's condition. For example, an employee has been diagnosed with HIV. Some people may have unfounded fears or stereotypes about HIV, believing that the employee poses a risk to others. However, modern medical evidence shows that HIV cannot be transmitted through casual contact, making the employee's presence in the work environment safe. In this case, if the employee's HIV status is impacting their ability to work due to related health issues, they should be considered disabled under the ADA. The decision should be based on factual, current medical evidence about the condition and its impact on the individual's work, not on misconceptions or outdated information about HIV. COVID-19, particularly in its long-term form known as long COVID, can be considered a disability under the ADA and the Rehabilitation Act if it substantially limits one or more major life activities. This determination is based on an individualized assessment, considering the specific symptoms and their impact on the person's daily activities. For example, someone with long COVID experiences significant lung damage, leading to shortness of breath and fatigue, may be considered as having a disability because those symptoms substantially limit respiratory function and other major life activities. Similarly, if a person with long COVID suffers from persistent memory lapses and brain fog, which could substantially limit brain function, concentrating and thinking, which are also considered major life activities. However, not all cases of long COVID automatically qualify as a disability. The condition or its symptoms must significantly restrict a major life activity for it to be considered a disability under the ADA and the Rehabilitation Act. This means that administrators need to be aware that staff or students with long COVID may require accommodations under the laws. The accommodations could include adjustments to teaching schedules, modifications to classroom setups, or other support measures to help individuals with long COVID fully participate in educational activities. As of 2017, out of 20 million individuals with disabilities aged 18 to 64, about 37% were employed, with teachers with disabilities constituting a significant portion of the workforce. In the context of employment, individuals with disabilities may still encounter discriminatory practices such as termination, denial of a promotion, or unwarranted negative evaluations. Educators and administrators must be vigilant in ensuring that their institutions comply with ADA standards, particularly in employment and educational practices. According to a 2021 article titled Avoiding Discrimination Litigation with Teachers with Disabilities on Litigation Review, the most common disabilities reported were depression, anxiety, visual impairment, attention deficit disorder or attention deficit hyperactivity disorder, deafness, and diabetes. The most common type of claim was the failure to accommodate a disability. In terms of outcomes, plaintiffs won in 45% of the cases, and they were represented in gray color. The defendants prevailed in 55% of the cases. Other types of claims included adverse employment actions, wrongful termination, and constructive discharge. Let's look at those claims one by one. First, failure to accommodate a disability. Employees with disabilities must be capable of performing the essential function of their job, either on their own or with some form of help known as reasonable accommodation. Employers are responsible for providing reasonable accommodations, such as making necessary facilities accessible and usable, restructuring work schedules, acquiring or modifying equipment, and providing readers or interpreters. If an employee develops a severe eye condition and their doctor recommends limiting time in front of a computer screen, and if the supervisor insists on assigning computer-based data entry tasks that are not essential functions of the employee's job, this could be a failure to provide reasonable accommodation. In this case, the employer should consider modifying the employee's job task or providing alternative assignments that don't require prolonged computer use. Here is another example. If an employee requires a disabled parking spot due to a surgery recovery, and the employer does not have available disabled parking, the employer is still obligated to explore reasonable accommodations. This could include creating a new accessible parking space, allowing the employee to use customer accessible parking, or other work-related adjustment if creating a parking space is not possible or presents an undue hardship. The employer must engage in an interactive process with the employee to identify a suitable accommodation. The interactive process means that the employer and employee with a disability must work together to identify an effective accommodation. This process includes open communication, where both parties discuss the employee's needs and potential accommodations. The employer may ask questions and request relevant documentation to better understand the employee's limitations and accommodation needs. The goal is to find a practical solution that allows the employee to perform their job effectively without causing undue hardship to the employer. Providing a reserved parking spot is a common form of reasonable accommodation, especially when it's needed due to a temporary disability like recovery from surgery. The refusal to provide such an accommodation, especially when it does not cause undue hardship to the employer, may be in violation of the ADA. In the case of Brown v. Milwaukee Board of School Directors 2017, Brown was an assistant principal for Milwaukee schools. In 2006, Brown began experiencing severe knee pain due to arthritis. The school district accommodated her by changing the location of her work and modifying her job duties. It excused her from breaking up fights and physically intervening with the students, which would normally be an assistant principal's responsibility. Those accommodations were managed by James Gorton, the district's employment specialist who continued to work with her throughout her employment. Brown later underwent knee replacement surgery. In 2009, not long after the surgery, Brown injured her knee again while restraining an unruly student. She had another surgery. Her doctor then restricted her to sedentary work with no student interaction until further notice. In July 2010, Brown was assigned to a new school. She found that she was expected to patrol the hall and be involved in student contact. She called Gorton and told him that she still needed to avoid interaction with volatile students. Her doctor also told Gorton that Brown should not be in the vicinity of potentially unruly students. That restriction was permanent. It would not be removed for at least 3 to 4 years, if ever. Gorton immediately told Brown that she could not continue working as assistant principal and that she would be on sick pay while he worked with her to find a new position. Gorton tried to find suitable job positions for Brown by identifying 8 potential positions, but none were suitable due to requirements for being in the vicinity of potentially unruly students. Approximately 2.5 years after her leave began, Milwaukee schools informed Brown that she had nearly exhausted the 3 years of leave of absence to which she was entitled. Brown's doctor inquired about the duties of an assistant principal, to which Gorton responded, emphasizing that the role involved interaction with potentially unruly students and requested an update on Brown's work limitations. The doctor stated Brown could return to work with certain restrictions, specifically avoiding responsibility for managing potentially unruly students. Milwaukee schools then reviewed its job vacancies and found 4 positions, including charter school program officer and student services coordinator. However, they concluded that Brown's inability to work around difficult students made her unqualified for her previous role and most of the vacancies. And the last position was a promotion for which she was not the top candidate. As a result, Milwaukee schools terminated Brown's employment. Brown filed a lawsuit for the failure to accommodate her disability under ADA. The Seventh Circuit ruled in favor of the school district, noting that nearly all the alternative jobs Brown considered as reasonable accommodations would have necessitated a proximity to students, which her condition prohibited. The only job that did not require was the Title I coordinator. The school district considered this position a promotion for 3 reasons. First, a higher pay grade for Brown. Second, an increased salary due to both the pay grade change and year-round work. And third, significantly more responsibilities. Brown disagreed, believing it was not a promotion since its salary range overlapped with her assistant principal salary and because she had previously moved between pay grades without such moves being classified as promotions. However, the court noted that whether a job is a promotion is not based on employees' perception. Under legal precedents, reassignments should be positions equivalent in pay and status. In previous instances, although Brown moved between pay grades, her salary did not change. She had not provided reasons why similar conditions would apply here. Significantly, Brown does not dispute that Title I coordinator role would have increased her salary by about $20,000 annually, involved a full year work compared to her previous 10-month schedule, and carried more responsibilities. Considering those factors, a reasonable jury would likely see this as a promotion, which the ADA does not require to be offered as an accommodation. The court concluded that the ADA did not oblige the school district to promote her as a form of reasonable accommodation. After discussing failure to accommodate a disability, let's look at another common claim: adverse employment actions. Adverse employment actions claims refers to materially adverse change in the terms and conditions of employment that is more disruptive than a mere inconvenience or an alternation in job responsibilities. Adverse employment actions could be demotions, reduced responsibilities, wrongful termination, constructive discharge, or other major changes that negatively affect their work life. Constructive discharge occurs when an employee resigns due to work conditions that have become unbearable, usually due to discrimination, harassment, or retaliation. This concept is based on the premise that the resignation was not truly voluntary, but was essentially forced due to the employer's conduct creating a hostile work environment. The conditions must be so intolerable that a reasonable person in the employee's position would feel compelled to resign. In legal terms, a constructive discharge is treated similarly to an outright dismissal by the employer. For example, an employee with a disability is consistently denied reasonable accommodations, leading to a work environment that becomes untenable. Another example is that an employee with a mental health condition resigns due to the employer's persistent refusal to allow flexible work hours or a quiet workspace as recommended by a healthcare provider. Those examples demonstrate how an employer's failure to accommodate a disability can create a work environment so intolerable that resignation becomes the only viable option for the employee. The claims of adverse employment actions often hinge on whether the adverse action was directly related to the employee's disability. For example, in the case of Solomon v. Southampton Union Free School District 2012, Sharon Solomon was an African-American special education teacher with a condition that caused pain, stiffness, and difficulty opening or closing her mouth. In the 2003 and 2004 school year, Solomon was transferred to an intermediate school. There, she met with Principal Tim Fraser and taught between 2003 and 2004. During this period, she received 2 reprimands from Fraser. In 2006 and 2007 school year, Solomon was initially transferred back to the high school to teach life skill programs, but was moved back to the intermediate school by the end of the year. The school district stated this was due to her potential as a resource room teacher, while Solomon attributed the transfer to concerns about her job performance. In June 2007, in a meeting with the school principal, Fraser discussed her transfer. Fraser allegedly berated her, commenting on her unpopularity with staff, poor performance, and telling her she would not be transferred again. He also restricted her from working on her dissertation or supervising after-school activities and required her to document everything. Back at the intermediate school, Solomon was assigned to a shared classroom with 2 other teachers, which she found confusing for students. She expressed interest in supervising the homework club, but was allegedly told by Assistant Principal Mark Patterson that no one else was being hired, although later 2 white teaching assistants were appointed. Solomon filed complaints with the New York State Division of Human Rights, alleging race and gender discrimination and later retaliation and discrimination based on her disability. In 2008, she received memos from Fraser and Peterson regarding her absences and failure to provide adequate lesson plans, which she contested, citing her disability and approved leave for her absences. Solomon received a poor evaluation from the assistant principal Peterson, primarily due to those absences, which she again attributed to her disability. The court found legitimate, non-retaliatory reasons for the action taken against Solomon, such as her failure to provide lesson plans, which justified the administrative actions. Regarding the hostile work environment claim, the court stated that the conduct must be severe and pervasive enough to significantly change work conditions. Solomon's allegations of harsh treatment by her supervisor did not meet the threshold to establish a hostile work environment under Title VII standards. The court emphasized that a hostile work environment claim must be supported by evidence showing the workplace is permeated with discriminatory intimidation, ridicule, and insult that significantly impacts the victim's employment conditions. But the evidence presented did not sufficiently demonstrate that the actions were based on discrimination due to race, gender, or disability. As a result, the court ruled in favor of the school district, finding no evidence of discrimination or retaliation under Title VII and ADA. Let's look at one more case. In the case of Barnett, the school district of Lancaster, Mary Barnett was a 57-year-old recovering alcoholic. She was employed as a learning support teacher and received positive evaluations until she disclosed her alcoholism in December 2011. Within a month, the school principal gave Barnett an unsatisfactory evaluation and stated that her deficits are significant and persistent. 2 months later, Barnett was called to a meeting with the school principal and the school district's director of human resources. In the meeting, Barnett was pressured to resign effective June 2012. The HR director also threatened to report Barnett to the Pennsylvania Department of Education for incompetence to revoke her certification unless she resigned from employment. Barnett filed a lawsuit against the school district, the school principal, and the HR director, alleging violation of multiple laws, including the 14th Amendment, Age Discrimination in Employment Act, and Americans with Disabilities Act. She accused them of wrongful termination and emotional distress. The court found that the timing of Barnett's negative evaluation after her disclosure of alcoholism suggests the decision may be based on her disability. It can be inferred from the temporal relationship between Ms. Barnett's disclosure and the school principal's negative evaluation, and the principal began to regard Ms. Barnett as being disabled, and that his subsequent conduct towards her, that is, the adverse employment action, was based on that disability. As a result, the court ruled in favor of Barnett. The cases I introduced today highlight the importance of educational administrators to understand and carefully handle disability accommodations in the workplace. Here is my question for you. How can you better ensure reasonable accommodations of disabilities and prevent adverse employment actions? Feel free to leave your comments below. Thanks for watching. I'll see you next time.